Hi, in this video blog I continue my discussions on the changes to employment legislation that have been proposed by the Employment Standards Legislation Bill. That bill is currently between its first and second reading. It's due to be reported back to Parliament in February 2016. In this video I want to talk about the changes which that bill proposes to the Employment Relations Act. In particular, I want to talk about the strengthening of the enforcement of the employment standards, changes to employers' obligations around record keeping, how the bill proposes to address issues with zero-hour contracts, and also talk a wee bit about some changes to the employers' obligations around secondary employment and shift work. So first up, the strengthening of the enforcement of employment standards. Now I'm not going to spend too much time on this, that's a subject in its own right, and I'll cover that in a wee bit more detail in a later video when I talk about the employment standards themselves. However, what the bill proposes for the Employment Relations Act is that mediation, whilst it remains the primary problem-solving method available for issues with employment relationships, the bill proposes that the enforcement of employment standards generally not be addressed at mediation. Rather, it's going to provide some additional powers to labour inspectors, to the Employment Relations Authority and the court to enforce employment standards. The employer's obligations to keep records relating to minimum entitlements will change under this bill. What the bill proposes is that employers must keep records in sufficient detail to demonstrate that they have complied with the minimum entitlement provisions. The bill defines the minimum entitlement provisions as being the entitlements and payments under the Holidays Act 2003, the Minimum Wage Act 1983 and the Wages Protection Act 1983. So one of the ways that the Employment Standards Legislation Bill seeks to address the zero-hour contract issue is by giving some meaning to the term agreed hours of work. So what the bill does is it proposes that agreed hours of work will be defined to mean any applicable hours of work specified in the collective agreement and any agreed hours of work included in any additional terms and conditions of employment. For example, an individual variation to the hours of work for someone who's covered by that collective agreement. Now, where the employee is covered by an individual employment agreement, agreed hours of work means any hours of work specified in that agreement. The bill goes an extra step by proposing a new obligation on the employer in respect to employees covered by an individual employment agreement, and for employees covered by a collective but who have an individual arrangement for their hours of work. Now, this obligation is that the employer must ensure that the employee's agreed hours of work are specified in the individual employment agreement or the intended individual terms and conditions, and that the employer must retain a copy of that individual agreement or proposed terms and conditions. The second way the bill proposes to address the zero hours contract issue is through defining the term availability position. Now, the bill proposes that an availability provision is where three conditions exist. The first is that the employee's work is conditional upon the employer making work available. The second is there's no obligation on the employer to provide work or make that work available. And the third is that the employee is required to be available to accept any work the employer makes available for them. Now, all three conditions need to exist. An availability provision may relate to all the work performed under the employment agreement or to work performed during hours that are additional to any agreed hours of work. The bill proposes to make an availability provision unenforceable unless the employment agreement provides for compensation to the employee for making themselves available to work. Under the bill, the employee will be entitled to refuse work if their employment agreement does not provide for compensation to them for making themselves available to work. Now, the bill states that for the purposes of satisfying the compensation under the availability provision, that the employer and employee may agree that the employee's remuneration includes compensation for them being available, where their employment agreement contains two things: an availability provision and the employee being remunerated for the agreed hours of work by way of salary. The final aspect around the 0 hours in the bill is a protection mechanism for an employee who refuses to accept work under an availability provision. So where there is an availability provision and there's no compensation, then the employee is entitled to refuse, and they cannot be subjected to any adverse treatment by the employer. The next change, or proposed change, I want to talk about will apply to your organisation if you currently have a shift arrangement. What the bill proposes is to put some limitations and some compensation in place for when an employer can cancel a planned shift. So the bill proposes that an employment agreement, whether it's collective or an individual, must specify a notice period required to cancel a shift, and that compensation must be paid where the shift is cancelled without giving that stated notice. Now, this means that an employer will not be able to cancel a shift without giving them required notice or without compensating the employee for the cancellation of that shift. So the bill sets out some criteria for when compensation must be paid when a shift is cancelled. The first criteria is where the employment agreement, whether that's the collective or the individual, does not contain a notice period for cancellation of the shift, or it doesn't include the amount of compensation to be paid. The second is if the shift is cancelled without being notified until the start of the shift. And the third is the shift has already started and the shift is cancelled before it is concluded. So in these circumstances, the employee is entitled to be paid what they would have earned had the shift continued as originally planned. What the bill is looking to do here is to make any provision that prohibits or restricts secondary employment unenforceable unless there is a genuine reason for having such a provision. And that reason needs to be based on reasonable grounds, and the reason is stated in the employee's employment agreement. So it's going to be quite important for employers to get right. The bill proposes some guidance on what a genuine reason may be for prohibiting or restricting secondary employment. So there are 4 pieces of guidance given. So the reasons may be protecting the employer's commercially sensitive information, protecting the employer's intellectual property rights, protecting the employer's commercial reputation, preventing a real conflict of interest. And that last one's important, a real conflict of interest, not a perceived. It has to be a real conflict of interest. So there you go. There's some of the changes which are proposed to the Employment Relations Act by the Employment Standards Legislation Bill. I haven't gone into all the changes. I've just covered in brief the main points which I believe that you as an employer need to be aware of. Now, if you need some assistance or would like to know a wee bit more about how these proposed changes may or may not impact on your organisation, feel free to contact me. My contact details are on screen. There'll be some more information posted on my website. Feel free to visit that and help yourself to the resources available there.